If the company is the primary vehicle of modern enterprise, the contract is its engine. Every commercial transaction, from a simple purchase of goods to a complex cross-border merger, is founded upon the principles of contract law. This body of law provides the essential framework that transforms promises into legally enforceable obligations, thereby creating the certainty and predictability necessary for a market economy to function. This chapter delves into the complete life cycle of a contract, governed primarily by the Venerable Indian Contract Act, 1872. We will begin by deconstructing the anatomy of a valid contract, examining the essential elements that give it legal force. The journey will then proceed through the performance of contractual duties, the various circumstances that lead to a contract's discharge, and the remedies available in the event of a breach. Furthermore, we will explore several specialized commercial contracts, such as indemnity, guarantee, and agency. Finally, the chapter will bridge the gap between this traditional legal framework and the digital age, analyzing the validity of e-contracts and the nascent legal challenges posed by automated smart contracts. The Indian Contract Act, 1872, provides a precise and foundational definition in Section 2(h). An agreement enforceable by law is a contract. This definition reveals that a contract is composed of two distinct elements: 1, an agreement, and 2, its enforceability by law. Without both, a contract does not exist. Agreement. An agreement is the meeting of minds between two or more parties. As per Section 2(e), every promise and every set of promises, forming the consideration for each other, is an agreement. Enforceability. This is the critical element that distinguishes a contract from a mere social promise. An agreement to have dinner at a friend's house is a social agreement and is not enforceable, whereas an agreement to sell a car for a specified price is intended to be legally binding. For an agreement to be legally enforceable, it must satisfy the conditions laid out in Section 10 of the Act, along with other implicit requirements established by judicial precedent. These are the essential pillars of a valid contract. Contracts can also be classified based on their validity, formation, or performance. For a business manager, every negotiation and agreement should be viewed through the lens of Section 10. A deal is not a deal until it is a legally enforceable contract. Before committing resources or making promises, a manager must mentally run through the checklist. Is the offer clear? Is the acceptance unconditional? Is there valid consideration? Do all parties have the legal capacity to contract? Is the purpose lawful? Overlooking any of these essential elements can render an agreement worthless, exposing the business to significant financial and reputational risk. A casual email exchange might feel like an agreement, but it may not stand up in court if it lacks certainty or a clear intention to be legally bound. Having established the essential elements, we now delve deeper into two of the most critical pillars: consideration, the what of the deal, and capacity, the who of the deal. Consideration is a legal term for the value exchanged between parties. The Indian Contract Act, 1872, in Section 2(d), defines it as something done at the desire of the promiser. As a general rule, consideration need not be adequate. The law requires that it has some value, but parties are free to make their own bargain. As a general rule, an agreement made without consideration is void. However, Section 25 provides three notable exceptions. These include a written and registered agreement based on natural love and affection, a promise to compensate for past voluntary services, and a written promise to pay a debt barred by the limitation law. For a contract to be valid, the parties entering into it must have the legal capacity to do so. Section 11 of the Act specifies who is competent. This means three categories of persons lack capacity. 1. Minors. An agreement with a person who has not attained the age of majority is legally void. The law was settled by the Privy Council in the case of Mahori Bibi vs. Darmodas Ghose. 2. Persons of unsound mind. A person must be capable of understanding the contract and its effect. An agreement entered into by a person of unsound mind is void. 3. Persons disqualified by law. Certain other persons are disqualified by specific statutes such as alien enemies, convicts, and insolvents. This underscores the critical need for due diligence. Verifying the identity, age, and legal status of the other party is a fundamental risk management check. Once a valid contract is formed, the primary duty of each party is to fulfill their respective promises. This fulfillment is known as the performance of the contract. The obligation to perform rests on specific individuals. If the contract involves personal skill, the promiser must perform it personally. Otherwise, a representative can perform the promise. Sometimes the promiser offers to perform their obligation, but the promisee refuses to accept. This is known as a tender or attempted performance. A valid tender has significant legal consequences. The promiser is not responsible for non-performance and does not lose their rights under the contract. Discharge of a contract means the termination of the contractual relationship between the parties. When a contract is discharged, the rights and obligations of the parties come to an end. A contract can be discharged in several ways, including by performance, by mutual agreement, by impossibility of performance, by lapse of time, or by breach. Every contract will eventually end. A good manager plans for this from the beginning by including clear termination clauses and understanding concepts like novation and frustration. Beyond simple transactions, contract law provides for sophisticated agreements designed to manage risk. A contract of indemnity is a promise by one party to save the other from loss. An insurance contract is a classic example. A contract of guarantee is a tripartite agreement to perform the promise or discharge the liability of a third person in case of their default. The surety's liability is secondary and arises only upon the default of the principal debtor. The key distinction is that an indemnity is a promise to cover a loss, while a guarantee is a promise to pay someone else's debt if they fail to do so. Contracts of bailment and pledge involve the temporary transfer of possession of goods. Bailment is the delivery of goods for a purpose, like repair or safe custody, with the obligation to return them. A pledge is a special kind of bailment where goods are delivered as security for a debt. The key distinction is the purpose. In a pledge, the purpose is always to provide security. Agency is a relationship where one person, the agent, is employed to act for another, the principal. This relationship can be created by express or implied agreement or by ratification. Agency is the legal foundation for almost all business operations. Every employee acts as an agent. The critical issue for managers is defining the scope of authority for each agent to prevent them from binding the company to unfavorable contracts. The Information Technology Act 2000 provides the legal backbone for the digital economy in India, giving legal recognition to electronic transactions and contracts. Section 10A validates contracts formed electronically, like click-wrap agreements where a user clicks "I agree," and browse-wrap agreements where use of a site implies acceptance. The IT Act provides for two types of legally valid signatures: the highly secure technology-based digital signature and the broader technology-neutral electronic signature. A company sends a purchase order to a supplier via email. The supplier replies with an email confirming acceptance and attaches a digitally signed copy of the order. This exchange creates a valid and legally enforceable contract. Managers must ensure their digital contracting processes are robust, preserving a verifiable trail of communication and using legally valid electronic signatures for high-value agreements. Unforeseen events can make the performance of a contract impossible. The doctrine of frustration applies when a contract becomes impossible or unlawful to perform due to a subsequent event beyond the party's control. The effect is that the contract becomes void and the parties are discharged from their future obligations. While frustration is a legal doctrine, businesses proactively manage this risk through force majeure clauses. This is an express contractual provision that excuses a party from performance. The clause typically contains a list of specific events such as acts of God, war, strikes, or pandemics. It is wider and more flexible than the doctrine of frustration. The global disruptions of recent years have shown that force majeure clauses are not just legal boilerplate, they are critical for business resilience. A smart contract is not a contract in the traditional sense. It is a self-executing computer program which is intended to automatically execute, control, or document legally relevant events. Its core features are automation, where code executes when conditions are met, Immutability, as it generally cannot be altered once deployed on a blockchain, and decentralization. The rise of smart contracts presents several novel legal questions when mapped against the Indian Contract Act. How do you verify legal capacity? How can a contract be rectified if there is a bug in the immutable code? If the parties are in different countries and the code runs on a global decentralized network, which country's laws apply? For now, complex relationships are best governed by traditional contracts. The future may lie in hybrid models that combine the certainty of legal prose with the efficiency of automated code.